Good morning, Monando. We are very pleased to be able to welcome those who have been with us for the webinar Intellectual Property Rights, an exclusive study on trademark on behalf of Department of Management Studies, Nirmala Arts and Science College, Manandurthi. And today we are blessed with the presence of none other than Advocate Sudhin Kumar K, an eminent advocate on Central Government Council, completed Advanced Executive Program for Asian School of Cyber Laws, Pune. Welcome, sir. The idea of putting foundation of an education institution is so inspiring. What was once planted as a sapling is grown to a large tree right now. So here I pray to extend my warm welcome to our college manager, Sri George Kuriakos sir, to this function. Welcome, sir. A smile costs less than an electricity, but it gives more light. My next welcome goes to the lady who holds such a smile, always who brings more light to our college, who we wholeheartedly welcome Professor Daisy Ono, who is always with us. Welcome, ma'am. We are honored to have Dr. Geeta C.A., principal of our college, with us today. Despite her busy schedules, we welcome you, madam. And at last, but not the least, a sincere welcome to all faculties and academicians from different institutions to this webinar. Thank you all. Thank you.
Can you start, sir?
Keynote speaker in this webinar, Advocate Sudhin Kumar, Dean Professor Daisy, Principal Dr. Geeta, Sri Unnikrishnan, HOD of Management Studies, distinguished faculty members and other dignitaries who are present for the webinar, and my dear students. Good morning to you all. It gives me great pleasure to preside over this webinar on intellectual property rights. Intellectual property rights can be broadly said as the rights given to a person or the creation of his mind. These rights are legal rights governing the use of creations of human mind. They usually give the creator an exclusive right over the use of his creation for a certain period of time.
Good morning, everyone. Respected resource person of the day, Advocate Sudhin Kumar K. Respected manager, Sri George Kuriakos sir. Dean Daisy ma'am. HOD of Management Studies, Nirmala. IQAC coordinator, Maithili Raja. Dear faculty members, participants from other colleges, and my dear students. First of all, I would like to appreciate the efforts taken by the Department of Management Studies and IQAC to organize a webinar on intellectual property rights, an exclusive study on trademarks.
First of all, I would like to thank all of the persons who have given me the chance to, give you a lecture, not a lecture, actually discussing about the IPR and the trademarks, importance of trademarks in the business as well. So I would like to thank the managers, Sri George Kuriakos sir, then the dean, Sri Mary madam, then the principal Geeta madam, and obviously Sri Unnikrishnan sir, who has contacted me to give you the classes from it. Let's not take it as a class or a lecture that you get in the college. Let's take it as a discussion on IPR and the trademark. Because I'm not a person who's so excellent in taking lectures. So I can discuss with you the aspects of trademarks and aspects of IPR. As already been introduced by the manager as well as the other speakers who had spoken earlier, that IPR is intellectual property rights. It means it actually has the connection with the human mind. It's a creation of human mind. So it has to be recognized because every creation of human mind has importance in the life. The human mind and the creativity is the only that proves that the existence and the development of life and the business in world. So first of all, let's start with IPR. What are the IP rights? First, as said by the manager, there are two kinds of IPR, intellectual properties. We can classify them as broadly as the industrial rights and copyright. The industrial rights are basically concerned with the trade and industry, manufacturing, business and all. Obviously, copyright also has importance in the industry, but it is actually a different kind of right. So industrial rights are mainly patent, trademark, and geographical indications and designs. So what is a patent? Patent is an exclusive right given to a conferred to a person who has invented a product. So what is invention? Invention means it's not discovery. It is creation of something which is not existent. So it has to be a new product. Novelty has to be there. It need not be a product always. It may be a solution, a technical solution as well. So patent means for the right given to a person. Patent means a right given to a person who has invented a product or a solution or a new method to a creation of something. For example, TV was an invention. Mobile phone was an invention. Now we have different kind of mobile phones, but the methods or the softwares used in or the chipsets used in the mobile phones are different. So if you find out a new chipset or new method for creating a chipset, that's again an invention. And for that you will get the patent. So major electronic companies have fought for patents, and it's still fighting for the rights over many of these aspects. The man who has most number of patents till now is Thomas Alva Edison. He has created more than thousands or 10,000 of or the company he established, that is General Electric, have more than 10,000 patents. Now tech giants like Apple has patents, Samsung has patents, and even India, the patents or the area of patent is much less in India, though we have it. India, the area is a little weaker considered to America, US or the Chinese or the Japan industry. Now coming to trademark, that we will deal with later, but basic concept of the trademark is that it should identify, it should distinguish the source of the product, and it should distinguish the quality of the product, origin, and it should distinguish the product from that of the others. That is the basic concept of trademark. Then there is geographical indication. So we all know Aramula Kannadi. Why is it so famous? Because the method of creating Aramula Kannadi is different from that of others. So that Aramula mirror can only be made in Aramula, and that knowledge is limited to certain families. And that's why geographical indications came in. We know Scotch whiskey. We cannot sell whiskey if it is made in Kerala as named as Scotch whiskey. It has to be made in the Scotch whiskey. For you, if you want to sell a whiskey in the name as Scotch whiskey, it has to be created. It has to be made in brewed in Scotland. So likewise, we have ഇപ്പോൾ നമ്മുടെ നാട്ടിലെ നേന്ത്രക്കായ അതിന്റെ വരെ geographical indication കിട്ടിയിട്ടുണ്ട്. Nagaland pineapple has geographical indication. Kolhapuri chappal has geographical indication. Then Puneri vada pav. Vada pav is a food item sold in Pune. It is Puneri vada pav. So Pune has got the geographical indication, and countries are fighting for it. Basmati rice is one of the examples. Basmati rice, though it is cultivated mainly in India, Pakistan and China, US companies had applied for the geographic indication and patent and also other aspects. The fight is going on. It is yet to be decided. So geographical indications basically indicate the product or the service with that of particular geographical area, locality. Then there is designs. Basically, design means a design or a shape, even it is a 3D shape of a product which can be recreated for business. Manufactured, recreated means manufactured again and again. So the bottle of a Coca-Cola drink, it's a designed bottle. That design cannot be used for other drinks. Like Pepsi cannot use it again. The design of Coca-Cola. That's why if we think that every 5 years, after 5 years, these bottles, even the distillery bottle or the Aquafina bottle, everybody changes their design, because design is only protected for 5 years. After that, anybody can use that design. It's only not to create a monopoly over the design, because business evolves after the developer, everybody else is given a chance to use the same. That's how business evolves. So you cannot have a monopoly. That is not actually intended for in the business field. If you have a monopoly, earlier times we had monopoly, spices monopoly was there. That has to be destroyed. That has to be changed, because people have to get the benefit of it. Otherwise, it will, create a monopoly, or the use of it will be given to a certain group of people, basically the corporations, big corporations. And that's not what intended. And that's why legislation came in. So these are the industrial rights, and there are other industrial signs also. That is trade secret. Trade secret means they are not given, they are not registered, but they are given recognition. Trade secret. Coca-Cola drink, we know Coca-Cola drink, how it is created. It's a trade secret. The masala, famous MDR masala, the family only know the trade secret. It's a secret. It has to be kept secret. If you register it, after 20 years you lose it. After 10 years you lose it. The secret is gone. Everybody can use it. And that's why it is known as secret, and it's always kept secret. Then copyright. What is copyright? Copyright is different from the industrial right. Copyright is so important in every aspect that we all know, we all copy the textbooks. Are we permitted to do so? No, in fact, no. Cases are being fought on. Copyright is a right given to an author or an artist for his creation, either a book or an art. And the right is given for 60 years, because he, using his mind for a long time, creating a beautiful book, creating a beautiful literature, creating a beautiful painting like Mona Lisa. Now everybody can use Mona Lisa, everybody draws it. So copyright is the right given to author or the artist who creates the literature or the artistic works. The softwares, algorithms are protected by copyright, because it's a creation in the literature style or the artistic style. So that is the most, the limit is, the right given is for 60 years. For patents, it's for 20 years. That's for the purpose of getting the benefit to each and every human being, the benefit of it. Then trademark is for 10 years, which can be extended up to lifetime. Then designs are for 5 years. So this is the basic concept of IPR. Court said that nobody has the right. Nobody has the right to represent his goods as that of other person's goods. That is the basic concept of trademark. The concept of trademark, it was mark earlier, then the trademark, the mark involved in trade. The concept of basic trademark even now stands as the same. Nobody has the right. No person in this world has the right to represent his goods or products as that of other person who also plays in the same field. This is the basic concept. I repeat it again. Nobody has any right to represent his goods as the goods of somebody else's. This is the basic concept of trademark. I hope all of you have understood the basic concept. Then let's start with the registration of trademarks in the earlier times. So 1618, this law came in, so people have understood the necessity for legislations. So in 1751, the country France had asked the manufacturers of furnitures to mark their prints on the furnitures they produce. It is for the purpose that he should not. It should be different. It should be different from that of the others. So same kind of furnitures were made, but with different seals to identify the source. Then in 17, it was in 1751 the France asked. Then in 1719, Thomas Jefferson, USA, then cabinet secretary there. Thomas Jefferson uh, uh, created a proposal in the Congress for a legislation for recognizing the trademarks or registering the trademarks. Unfortunately, that was not accepted. That proposal was not implemented. So it can be treated as the first attempt to legislate, legalize the modern trademark system. But that unfortunately became a failure. Then the first comprehensive attempt to legislate the trademark system was introduced in France. It is known as the law of marks on merchandise, manufacture and trade. This is the first attempt made by the humans to create a law on trademark or the comprehensive style for registering the trademarks. So it came in France in 1857. Then in 1890s, 1870s, first mark was registered in USA. First trademark was registered in USA. It is known as the Avril Chemical Paint and Company. So we can say that it is the first registered marks, though there are claims to say that there are other marks which were registered much prior to that. So with the results from the World Intellectual Property Organization, this can also be treated as the first registered trademark. That is Avril Chemical Paint Company, registered in 1870 in the US. Then 1874, Germany introduced the law. And then again in 1875, the Great Britain passed an enactment. Earlier it was England. Then Great Britain passed an enactment identifying and understanding the importance of registering the trademarks. It is known as the Trademark Registration Act in 1875. And first mark was registered immediately, that is in 1876 in Britain. That was Bars and Co. Pale Ale. It is a beer company, a beer product. Many of the first marks were registered by alcoholic or beverages companies. And the mark registered in 1876 is still in use and is still valid. That's the importance of it. 1876 mark is still in use and it's still valid. Then the 1881, the earlier law in US was said to be unconstitutional for various reasons. So a federal law was introduced in 1881. See, we are seeing the history, so just starting from the earlier barbarian times to the modern times, and just conveying the history. In 1883, the major step of recognition of trademarks and the other IPRs throughout the countries in the world was necessitated, and the Paris Convention in 1883 was introduced. 11 countries agreed to recognize the IP rights. As in 2017, there are 177 members and India is one of them. So it started as early as in 1883 in the Paris Convention, and that Paris Convention stands on 2017 at 177 members. From 11, it increased to 177, which means that the international trading community has started identifying the intellectual property rights, including the trademarks, importance of trademarks, importance of business, has already been identified. Then coming to 1893, the world's most famous trademark was registered in, that is Coca-Cola company's trademark. It is written Coca-Cola in the red color, red and white color. It was registered in 1893, and we know that it's still being used, and we know that it is going to be used for a long time as well. The first attempt to legislate in India was in 1938. That the Trade and Merchandise Act. The Trademarks Act. That was the adaptation of the English law, because we were being ruled by the British people then. So India adapted the system that was existing in England from 1875 onwards, and as available from the records, the first mark that registered is black and white Scotch whiskey, again an alcoholic brand. It got the registration number as 10. So first 9 we don't know, the records are not available. So as long as from the available records, it is the black and white Scotch whiskey that was registered in India for the first time. Then in the modern India, after the government of India takeover, after the independence, in 1958, Trades and Merchandise Act was enacted. Then we got to understand the importance of Paris Convention, and the other protocols later came in, other treaties came in. The Pope introduced by World Intellectual Property Organization was created. Then the Madrid Protocol, recognizing the rights of persons internationally, recognizing the trademarks internationally came in. So after understanding all these aspects, Indian government again created a new enactment known as the Trademarks Act 1999. And this is the act that governs the field in India as of now. Now coming to what is a trademark. So we know what is mark. So what is trademark? Trademark is a sign. Trademark is a sign that distinguish the source of the product from that of the other competitors. So it mainly has got two functions. A trademark has to distinguish the product or the source, and it has to identify the source as well. So this is the trademark's basic definition. When coming to law, legal definition is different. Trademark is a legal definition as per the Trademarks Act is this. Trademark is a mark which is be capable of being graphically represented. അതായത് ചിത്രീകരിക്കാൻ സാധിക്കുന്ന ഒന്നായിരിക്കണം, എഴുതാൻ സാധിക്കുന്ന ഒന്നായിരിക്കണം. So a mark which is be capable of being represented graphically, and also it has to distinguish, capable of distinguishing the product, goods and service. Product in the sense goods and services. There are two kinds of products. There is goods and services. So it has to be capable of distinguishing the goods and products from that of the other competitors in the field. This is the basic idea. Let's start with, when we wake up, we all in one day come across around hundreds of patent trademark products. We wake up in the morning. First thing that we do is brushing our teeth. We use a toothpaste, we use a toothbrush. Toothpaste belonging to Pepsodent, Sensodyne, Close-Up, Colgate, Patanjali, and so on. So many brands are there. So we purchase according to our wish, our interest. We go for certain brand. Yes, that branding is important. For that, they advertise the brand so heavily that it has to stand out from the other competitors. So Pepsodent, for example, Pepsodent toothpaste, they advertise in such a way that it stand out from the close-up or the Colgate. Likewise, other companies also. So we purchase according to brand. Then toothbrush game. They have so many players in the field, so many toothbrush manufacturers. So we purchase one. I may purchase one brand, you may purchase a different brand. It's according to our interest. From starting from the waking up, brushing till we sleep, we come across around hundreds of trademark products, all of them. Be it a jeans, be it a chocolate candy that we love, be it the food that we have, be it the restaurant that we go, and be it the snacks that we have in the evening. Everything is a trademark product or has a trademark. So what is trademark? Again, the sign that distinguish the source and product from that of the others. What are the main functions of trademark? It has to distinguish. It has to identify the source. It has to distinguish what? The product, goods and services from that of the competitors. For an example, let's take laptops. There are so many laptops in the market. What will we go buy? To buy? We may go to buy an Apple one. We may go to buy an HP product. There are Lenovo products. There is Combat products. There is Acer. There is MI now in the field. So there are variety of brands. But what we choose is based on the quality and the economic status of us. How that is identified? The quality is identified. Quality is identified again with the brand. So trademark is important in business to identify or guarantee the quality. A brand which is well known, a brand name or a trademark which is known all to us only because it has a certain quality, it guarantees a certain quality. So trademark is important in the business to identify a particular product with its quality, with its original source, which guarantees its quality. These two functions, the distinguish function and the the source function, both which trademark has to have, are interrelated or overlapped. Because when we say that it has to distinguish the source, we say it also distinguishes the product from that of others. Both functions are overlapping. അതായത് സോഴ്സിനെ കാണിക്കുമ്പോൾ തന്നെ ആ പ്രൊഡക്റ്റിനെയും ഡിസ്റ്റിങ്വിഷ് ചെയ്യണം. Now സോഴ്സ് എന്ന് പറയുമ്പോൾ ആ കമ്പനി ഉണ്ടാക്കുന്നത് ആരാണെന്നും ആ വ്യക്തിയാണെന്നും അറിയണമെന്നില്ല, ആ ബ്രാൻഡാണ് ഉദ്ദേശിക്കുന്നത്. ഇപ്പോൾ നെസ്ലെ എന്ന് പറയുന്ന കമ്പനി വി നോ, നെസ്ലയുടെ കീഴിൽ there are around 2000 different brands, and these 2000 different brands are well established, have a good reputation in the field. Likewise, Cadbury's has many number of trademark products in their name. So trademark is essentially a sign that distinguish the source of goods and services from that of the others. So what basically has the what basically a trademark do is that a trademark identifies the products of origin as earlier discussed. Then it guarantees the quality according to the brand. Then it advertises the product. We all know when we go to purchase a laptop, we get to know the brand only because of the purchase. The advertisements. So it is heavily advertising the brand product as well. HP laptop ഭയങ്കര നല്ലതാണ് നമുക്ക് എല്ലാവർക്കും അറിയാമെങ്കിൽ HP ലാപ്ടോപ്പിനെ അത് അഡ്വർടൈസ് ആണ് ചെയ്യുന്നത്. Then it creates an image of the product in our mind. Coca-Cola, we know what is it. Then we say a cricket ball, like say SG, it is associated with cricket. SG cricket ball associated with cricket, and the product is belonging to SG company. Likewise, we say what Splendor. What is a Splendor? What is Splendor? Splendor is a motorbike. Of whom? Hero Corporation. We say BMW. Again, a trademark. BMW actually belongs to a consortium, but BMW is a brand. BMW has different kind of models, different variety of models, but all belong to BMW. Likewise, we know the Ambassador. Ambassador is a car, and who is the manufacturer? Then Hindustan Motors. Likewise, when we think of a trademarked product, we identify the source, we understand that it has a certain quality, it guarantees a certain quality, and it advertises that product. That is the basic concept and basic understanding of trademark. This is what trademark does. And now that's what trademark is. Now we need to understand why is the trademark important in business. We all know the commercial activity is so high in the world now. So there are a lot of goods, lot of products available in market, and there are a lot of other different variety of brands producing the same kind of goods. So how a manufacturer can sell his product? How he can distinguish his product from that of the other? By trademarking it. Yes, that is the importance of trademarking. He gives a particular name to his product. It might be a tire, but he gives it a different name. It might be a car. He gives it a superb name to identify from the other manufacturers' products. Like an example, Hero has Splendor, Hero has Charisma, Hero has Hero Corporation has other bikes now in market. But we all know there are Bajaj Pulsar, Bajaj, other kind of Bajaj scooters. Then there is Suzuki Gixxer, Suzuki other motorbikes. Then there is Honda. All of them have over the years gained the name very well. But when we go to purchase it, what we choose? We choose first what we want, and in that category, which is the best. So, which is the best according to us? According to each different person, which is the best? How he identifies that the product is best. He might not have used it, but advertisement by branding. Our brand name identify when somebody goes to purchase product, he purchases a particular product, he identifies that brand name and purchase it. That's why in trademark is so important in the business now. For economic growth, it's very important. It's an unavoidable aspect of economy that the brands should register, brands should have a trademark or they trademark their product. Now we can say that there are a lot of famous trademarks in the world, like Coca-Cola, and in the same aerated drink field, there is Pepsi. Both of them are the giants. Coca-Cola has different products like Mirinda, like 7-Up, or the Sprite. I don't know exactly which belongs to Coca-Cola. So Coca-Cola in that field again has different products and with a different trade name, different trademark. That is 7-Up, then Mirinda, then Minute Maid, then Pepsi. Coming to Pepsi, Pepsi has also got different products in it. Aquafina is a Pepsi product. Coca-Cola also has a different product in the mineral water field. So every company has different products under different trademark. Even companies like Hindustan Unilever has different brands in same goods. That is soap. Dove is a mark owned by the Hindustan Unilever. Peers, Hamam, everything is soap that we regularly use in our daily life belong to one company, manufacturer, that is Hindustan Unilever. So to have a much wider range of products, to reach out to much wider range of people, അതായത് എൻ്റെ പ്രൊഡക്റ്റ് ഒരു വ്യക്തിയിൽ അല്ലെങ്കിൽ ഒരു ക്ലാസ് ഓഫ് വ്യക്തിയിൽ നിൽക്കുന്നതിന് പകരം that should reach out to each and every corner of this world. For that, branding is necessary. Different kind of branding, different products in the same category. We need to have different brands, and they might charge different in different way. Though the products are made of same quality, even then they charge differently, because people, the common public purchase according to their economic viability as well. So trademark, in fact, advertises and economically helps to economically grow a particular brand. One of the main and important aspect of trademark is that it should help to grow economically. Otherwise, that mark has no purpose. If a trademark name has failed to gain the popularity, then that trademark itself is a failure. The marking is itself a failure. Then there is no purpose in that trademark. If it fails to identify the origin or the source, that it's a failure. There are too many examples. There are many product names which we don't even know, though it has been in the market for years. It failed, it miserably failed. Maybe in India, but other countries might be using it for various reasons. So this is the concept of trademark, and this is how trademark is important in business. Now coming to the legislation. Legislation, why trademark? It is not necessary that you register a trademark, but it is always suggested. Not mandatory, but it's better to register. What are the benefits you get while registering the trademark? When you register a trademark, if somebody infringes your right to use it, infringement, which means that a person uses already registered mark with another person as his own. Say Coca-Cola is registered. I am using a brand name as Coca-Cola, maybe for another product or same product. Then the registered owner or the proprietor of Coca-Cola trademark has a right to sue against me under the law. So only the registered owner, the person who has the registered trademark, has the right to sue for infringement under the Trademarks Act. And the punishment is severe. It has a criminal two aspects. It is a civil as well as criminal. It has civil as well as criminal consequence. You may go to jail for around 3 years, a minimum of 6 months, maximum to 3 years, and with fine. If I take up the matter in civil courts, I may be, if somebody takes the matter up in civil court, the person who actually commits the crime, actually infringes the right of the person, may have to pay huge amount as fine. There was a case in India when TVS and Bajaj fought for a two-valve engine. They fought for it, and for infringement, I think that product TVS Flame was the bike's name that has to be stopped, and some compensation was about that to pay. And that's how registration helps you. Again, if you have not registered the mark, but it has gained much wider publicity, then again you are not left without remedies. You have a remedy for passing off. But it has it's not as easy as to prove the as in the case of infringement, because the registration itself or prima facie has a evidentiary value. But in the case of passing off, the person who alleges that my product is being or my trademark is being used by other has to prove that his name has been in the market for a long time. It has gained value. It is distinguishable from that of the other. That aspect is there. So basically, registration is required for protecting the trade and the business of that person. That's how trademarks are important in business and how it protects after it's getting registered. Then there are collective marks. What is a collective mark? We know Reliance, we know Nestle. There are other businesses like Cadbury, There are various companies under the Reliance group, but it is all Reliance. So that is a collective mark. Collective mark means a mark used by an association or group of person to distinguish their goods and services. Tata. Tata has so many companies, but it's Tata. Tata name has a value. Then there is well-known mark. So collective mark, then there is a well-known mark. What is a well-known mark? Basically, there are 42 classes of goods and services, 37 class of goods and 5 class of services. These classes has different variety of goods. One is alcoholic drink, then again beer and other alcoholic drinks, aerated drinks, clothes, and other all the goods that are being produced and sold have been identified and classified into 36 classes. And one mark may be registered in class 3, but it is not registered in class 7. Then another person can register the same mark in class 7. It is possible. But to avoid that, a well-known mark system came in. Well-known mark is a registered mark, and coin just acquired so much distinctiveness, so much name over the years by using it. Then, if one person uses the already existing well-known mark in the different class, he might not get the registration because the other mark has already been in use. It has been identified with a certain group. For an example, Tata. I cannot register a Tata nail polish now. It is because Tata is already there. Tata Group has different products, including starting from cars to steel bars. Now, if I start and I Motosuji Padunari class, if I try to register it as Tata product, though it is not registered, it might not be possible. It actually is not possible. എന്ന് പറയുന്ന പോലെ ഈ വെൽ നോൺ ട്രേഡ് മാർക്ക് വന്നു കഴിഞ്ഞാൽ വെൽ നോൺ മാർക്ക് വന്നു കഴിഞ്ഞാൽ they are highly protected. It's very difficult to register that name by another person in any other group. That is not possible. Then service marks. Service is the goods and service. So service is offered by like hospitals, restaurants, airlines. They offer variety of services. So these services are also classified into 6 or 7 classes, and they were permitted to mark. Now, one of the service mark is Air India, Air Lanka. Then there are hotels registered that like Karim's Biryani or Pandari's Biryani. They are in there. I don't know whether they are registered, but they are able to register it because they offer a kind of service to people. They can register it. Many services have been registered, like hospital is Taj Group, like the Marriott hotels. They also have registered their services. Now, then there is a trade description. What is trade description? It is similar as the trademark, but it actually gives a statement to identify the service or the goods that is associated with it. അതായത് എന്തിനെയാണോ ട്രേഡ് മാർക്ക് ചെയ്യുന്നത് അതിനെക്കുറിച്ചൊരു ഐഡിയ കൂടി കൊടുക്കുകയാണ്. An example is jasmine, fine vacuum salt. The word is jasmine, trademark is jasmine, but what is it? It is already identified by the description given to it. Fine vacuum salt. അതായത് ഉപ്പാണ്. ജാസ്മിൻ എന്ന് പറയുന്ന പേരിൽ വിൽക്കുന്നത് ഉപ്പാണ്. Air India. What is it? Air India. It is a service provider in the air transportation field. Likewise, there are others, many others. Raymond's, a complete man, can also be treated as a trade description. What is a complete man says is gives the perfect clothing. So these are the basic trademark concepts.
Okay. Okay, thank you very much. Your explanation is very simple, interesting, and very informative. Thank you.
So I take this opportunity to say convey my heartfelt thanks to all the office bearers of Nirmala College and those who have participated in this webinar and patiently heard me. I thank you all, and I hope you all have a good year ahead. we are going through a bad times, and I wish good time in these bad times. Thank you.
Thank you, sir, for this wonderful session. Now I request Ms. Ashita, Ms. our assistant professor, to deliver the vote of thanks.
Good morning, all. First of all, I extend my most sincere thanks to Almighty. Next, I would like to propose a hearty thanks to our resource person, Advocate Sudhin Kumar, for gracing today's webinar. Thank you, sir, for making this seminar meaningful and interesting. Next, I would like to express a profound gratitude to our manager, Sri George Kuriakose sir, our principal, Dr. Geeta ma'am, our dean, Professor Daisy ma'am, and our HOD, Unikrishnan sir, for their moral support and guidance. Last but not least, I am happy to express my sincere thanks to my faculty members and all the participants who have made this seminar a grand success. Once again, thank you all.